Ryan with Attorneys of Idaho. I'm here to talk to you about the process of a personal injury lawsuit. While every case is unique, understanding the general framework can kind of help you understand what might happen in your case. The first thing that always happens in a personal injury lawsuit, especially with a car crash claim, is medical treatment. What that means is right after you get into a car crash, you're hurt. You need to go to the hospital. Once you go to the hospital, you're going to have some recommendations as far as follow-up appointments. If you need to get any sort of surgery or any sort of really rehabilitation work done after that, it's really important that you go see the chiropractor or the physical therapist and continue through with your treatment. Often the medical treatment portion of your lawsuit can take upwards of a year just because it can take a really long time to recover from these types of injuries. And so it's important to work with your chiropractor or your physical therapist or your primary care physician and making sure you're receiving the treatment you need, going to those appointments and following up as needed. While you're working on getting better, our job is to investigate your case. That means we need to start getting together all of the police reports, witness statements, and other evidence that we can gather. That could include photos of your car, mechanic's statement as far as how much damage was done, any witness statements at the scene that said that the light was green or the light was red, any other evidence that we can put together. Sometimes if the police don't interview everybody that was a witness on the scene, we'll send Charles, our investigator, out to go talk to the other people that didn't get interviewed and to see what exactly they saw happen. We'll also work with other experts in determining if there's an issue with liability or damages in your case, making sure that we're getting on top of your treatment, helping to make sure that those injuries are directly related to your car accident, or working with a reconstructionist to make sure we can show that the other party was at fault for this car accident before we get into litigation or demand preparation. This initial investigation phase generally takes about the same amount of time as your treatment does. It can be 6 months or even longer. Once you're all better, or as better as you're going to get from your car accident injuries, then we're going to start moving forward with demand preparation. Demand is something that we send over to the insurance provider on the other side and say, here's an exact statement of every single medical bill that happened because of this crash, and a story about you and how this impacted your life and the lives of your loved ones. At the very bottom of that demand package, and every single one of them, is a settlement opportunity. And that settlement opportunity is a number that you and we have agreed on that you think would be a fair settlement for your case. This demand preparation can take a little bit of time, 1 to 3 months, because we need to make sure we have all of your medical bills and records together. And we need to be able to make sure that we've talked to you and your family to see how this has impacted you, so we can put together a really compelling story about what happened to you in this car crash and why you need some compensation to recover from it. Once we send that demand package over to the insurance provider, generally they're going to take a few weeks to evaluate it. They want to read through your medical bills, your medical records. They want to see what your story is as far as how this pain and suffering has affected you. And then they're going to send us an offer. Generally, that first offer is never the best one. It's very, very infrequently that we get the offer we wanted from the car insurance company. Now, we do something called a 12-120 demand in Idaho. What that means is we usually send a demand for $35,000 or around that amount and ask the insurance company to pay that. The reason for that is under Idaho Code 12-120, if your car accident claim is $35,000 or less and an insurance company lowballs you, then we can get attorney's fees on top of all of your other injuries and damages. Those attorney's fees are a huge leverage for us to try and get the insurance company to give you a much more reasonable offer. So oftentimes, we'll send that 12-120 demand, use that to try to negotiate your case quickly so that we can get you compensation as fast as we can. This negotiation step can take upwards of 2 months or even longer, depending on how long it takes the insurance company to evaluate your medical records, your story, and your claim. If negotiations fail, what that means is the insurance company doesn't give you a reasonable offer for your car accident injuries, then what we'll do is we'll move forward to litigation. To start litigation, we file a complaint. A complaint's generally just a short and simple explanation to the court of who was involved in the accident, exactly what happened, and why we're saying the other side's at fault. Generally in car accident cases, the issue is what's called negligence, or not paying as much attention as they should have been, or really just not being as careful as they should have been. That complaint's pretty simple and short, and the other side, the defense, will need to immediately hire an attorney and start filing an answer. An answer is essentially a response to every single bit of our complaint. Usually those attorneys for the car insurance company are going to say, no, it wasn't our insured's fault. No, it was not our driver's fault. And here are some defenses for why we don't think it was our fault, why it's not our responsibility to pay. Once that demand is filed, they only have 21 days to file the answer. And if they don't, sometimes they forget, we can file a default and start to move forward without the other person involved. Sometimes that works out where it's just you, me, and the judge trying to figure out exactly how much to compensate you for, and the other attorney never even shows up in the case. Now that's pretty infrequent, but since we stay on top of these complaints and make sure we monitor at that 21-day stage, we get defaults every once in a while. Once the other party has been served with the complaint, that means we usually send Charles or Jake down with the complaint to their home. They have to turn that over to their insurance provider, who hires an attorney for them. That attorney's job is to file the answer and then decide whether he or she thinks it's time to settle the case early or start moving the case into what we call discovery. Discovery is a pretty simple process that is made a little bit more confusing than it needs to be. Essentially, it's us sending a bunch of questions to the other side and them sending a bunch of questions back to us. Those questions are usually pretty simple stuff, like from them, they may ask us, how has this affected your life? What do you say happened that day? Show me any pictures you have of your car. What do your tax returns look like for the last few years? So you and I will sit down with our paralegal and we'll go through these questions, answer them all, and turn them back over. I'll also generally send out a list of these questions very early on after the complaint is filed. The questions we usually ask the other side are pretty simple too. What do you say happened? What is your car insurance policy? How much money are you insured for? Things like that to kind of get an idea of where they're at for the case. As discovery is ongoing, we'll set the case for depositions. Deposition is just a fancy word for having a conversation. So for a deposition, I would sit down with the driver of the other car and their attorney and ask them a bunch of questions. They get a chance, they get a bite at the apple and talking to you as well though. And so generally for a deposition, we'll get that scheduled at a time that's convenient for you, and we'll figure out exactly what happened from your perspective. From there, we'll make sure you're really prepared for your deposition, and then you can come by the office. We'll sit them down in the conference room together, and we'll have a conversation with the other side's attorney to make sure they understand how this has impacted your life and exactly what happened during the car accident. Oftentimes, this deposition step is where the insurance adjuster is willing to start thinking about a second settlement stage. Once they get to see who you are and have a chance to have a conversation with you through their attorney, that's when they really start thinking if this is a case they actually want to go to trial. Generally, a trial is much more risky for the insurance company because there's a chance they're going to lose a lot more money than if they simply came up with a compromise, and especially if we have a good deposition. Now, around the same time that we're working through deposition, if you brought us on board immediately in your case, we'd often have experts ready even before we go into litigation. If your case is a little bit older, that's totally fine. We can always interview experts as the case progresses into litigation. From there, we'll generally pick the case up and start working expert prep into these deposition phase and the discovery phase. We usually have up until about 6 months before trial to get our experts completely up to speed. And we don't generally want to waste any money on experts unless we absolutely need them, because that expert bill is paid out of the final settlement. So anytime experts are necessary, however, we will get them paid for, take care of the bill on your behalf, because again, you're not paying anything to come see us and make sure we get your case up to speed and prepared for litigation.